Federation versus Freedom by Baba Sahib Ambedkar. 4. D. Financial powers of the Federation. The revenues of the federal government are derived from four different sources: revenue from commercial enterprise, revenue from sovereign functions, revenue from tributes, and revenue from taxes. Under the first head fall all revenues from posts and telegraphs, federal railways, banking profits, and other commercial operations. Under the second head comes revenues from currency and coinage from bona vacantia and territories administered directly by the federal government. Under the third head are included contributions and tributes from the Indian states. The classification of revenue from taxes follows upon the powers of taxation given to the federal government by the Constitution. The powers of taxation given to the federal government fall into three main categories. In the first category fall those powers of taxation which is wholly appropriable by the federal government. In the second category fall those powers of taxation which are exercisable for raising revenue, which is divisible between the federal government and the provincial governments. The heads of revenue which fall under the first category of taxing powers cover those which are specifically mentioned is the federal list. That is, 1. Duties of customs including export duties. 2. Duties of excise on tobacco and other goods manufactured or produced in India except alcoholic liquors for human consumption, opium, Indian hemp, and other narcotic drugs and non-narcotic drugs, medical and toilet preparations containing alcoholic or any substance including in subparagraph B of this entry. 3. Corporation tax. 4. Salt. 5. State lotteries. 6. Taxes on income other than agricultural income. 7. Taxes on the capital value of the assets exclusive of agricultural land of individuals and companies. Taxes on the capital of companies. 8. Duties in respect of succession to property other than agricultural land. 9. The rates of stamp duty in respect of bills of exchange, checks, promissory notes, bills of lading, letters of credit, policies of insurance, proxies, and receipts. 10. Terminal taxes on goods or passengers carried by railway or car or air, taxes on railway fares and freights. 11. Fees in respect of any of the mailers in this list but not included fees taken in any court. In connection with this, attention might be drawn to the following items in the concurrent list. 1. Marriage and divorce. 2. Wills, intestacy and succession. 3. Transfer of property and other agricultural lands. Being in the concurrent list, the federal legislature has power to legislate upon which respect to these. Can the federal legislature also, while legislating upon them, raise revenue from them? The Act does not seem to furnish any answer to this question. It may, however, be suggested that the rules contained in Section 104 regarding the exercise of residuary powers will also apply here. The sources of revenue which are made divisible by the Constitution are 1. Income tax other than corporation tax, and 2. Jute export duty. Those which are made divisible according to the federal law are 1. Duty on salt, 2. Excise duty on tobacco and other goods, and 3. Duties of export. In respect to the financial powers of the Federation, there is one feature which, by reason of its peculiarity, is deserving of attention. The Act, in giving the federal government the right to tax, makes a distinction between powers to levy the tax and the right to collect it. And even where it gives the power to levy the tax, it does not give it the right to collect it. This is so in the case of surcharge on income tax and corporation tax. The income tax is only leviable in the provinces and not in the states, although it is a tax for federal purposes. The state subjects are liable to pay only a federal surcharge on income tax because such a surcharge is leviable both within the provinces as well as the states. But under Section 138(3), the federal government has no right to collect it within the states. The collection is left to the ruler of the state. The ruler, instead of collecting the surcharge from his subjects, may agree to pay the federation a lump sum, and the federation is bound to accept the same. Similar is the case with regard to the corporation tax. The federation can levy it on state subjects but cannot collect it directly by its own agency. Section 139 provides that the collection of the corporation tax shall, as of right, be the function of the ruler. The end.